Part 17 of X, There Was a Man, the Saga of Gordon Kahl, a True Story. Another selected juror testified that he had formed an opinion, albeit nothing that I would consider a strong opinion. Just for fun, assume ad absurdum that Gordon Kahl was berserk and insane, and that the four defendants were with him at the roadblock against their will. Given the conduct of the lawman, would the actions of the four at the roadblock have been significantly different? Food for thought. What about their rights? The government presented its case according to its planned scenario. It was an exercise in drama, cleverly camouflaged to elicit jury sympathy and indignation, punctuated by impressive ballistics and medical experts as figures of authority. As scheduled, it emphasized Yorie firing first and Scott executing Cheshire, and I repeat, both of which were known to be false by the U.S. attorneys. Efforts were made to defame character, such as Scott's problems with authorities, who tried to teach his 6-year-old sex education before instructing him on the ABCs. Impressive displays of weapons were made. Little or no substantial evidence as to the charges was submitted. In this regard, a preponderance of evidence is not sufficient to convict a person of a felony, nor is clear and convincing proof enough. The evidence is supposed to be beyond a reasonable doubt. Could reasonable doubt have been denied the defendants in this case? It would seem so to me. Perhaps sequestration of the jury for these weeks under the care of the U.S. Marshals could have been a factor. No one can prove the U.S. Marshals influenced the jurors, but few prudent people would doubt it. No doubt exists of their animosity towards the defendants, and who is to say a marshal's gesture or sneer would not have effect, even if no words transpired. Meals to the jurors were catered by a cafe managed by Paul Stallcup, nephew of slain Marshal Muir. To relieve tedium and to pass the time, the marshals participated with the jurors in a softball game on one weekend. Marshal Wigglesworth, one of the alleged victims of the assault, was observed with softball gear in a parking lot at the time. My talk about setting foxes to guard the chickens. Never mind, the appellate court said all this didn't matter. The prosecutors were overzealous, to say the least, in pushing their obvious advantage with Judge Benson. To illustrate, prior to the trial, the counselors reached an agreement which permitted Scott false statements to the government to be admitted into evidence without objection from the government, provided he took the stand subject to cross-examination. When his statement to the FBI was offered into evidence, the prosecutors objected. They welched on the agreement, latently asserting that it only pertained to polygraph results. As usual, the judge sustained and the appellate court agreed. Nevertheless, the instance is a classic demonstration of the nefarious conduct of the trial. Another example, near the trial's end, Fisher showed colored photographs of the dead men to the jury, saying, "This is what this case is about." The defense had stipulated that the men were dead and had died from gunshot wounds. The evidence presented by the government did not substantiate the convictions. I'm not saying this just out of the blue. I studied the case. Take David Brower. He only laid on the ground and prayed. Even though he was acquitted of assault, he was convicted of harboring and of conspiracy to assault. First, the evidence was far below the required level of proof needed for concealing and harboring. He did neither. Second, he was convicted of conspiring to forcibly assault, resist, oppose, impede, intimidate, or interfere with lawmen. To convict him, it is necessary for the jury unanimously to convict on one of the forcible means by which this was done. Of course, the jury didn't do this because the evidence just wasn't there showing conspiracy to forcibly do anything. The appellate court was no help here because no objection was made to jury instructions. Even With 2.5 weeks of testimony and scores of exhibits to consider, the jury was not out long in making its decisions. It amounted to about 15 minutes per charge for each defendant. The defendants each took the witness stand in his own defense. Grandma testified that they were ambushed. They all had the ring of truth in their answers. Grandma was acquitted on both charges, as no evidence existed against her except that she was at the scene. The only other acquittal was the assault charges against Brower. The judge was pleased at the outcome, but Crooks thought Grandma should have gotten at least 10 years. Sogard, whom defense pathologist Smith said was not too fat but just too short, conceded during the trial that he felt like David going against Goliath. He did resemble a little bit a bale of hay with the mid-strand busted. The immense resources and arsenal of weapons available to the Justice Department to prevail in a trial are simply not available to a country lawyer. Government expert witnesses came from Texas and Maryland. For instance, even though one FBI agent surmised the government couldn't afford to procure and store tapes for interviews, with the agents writing their version of what was said being the convenient alternative, sometimes omitting or altering key statements. The thrust of Judge Benson's position was that there was no such thing as self-defense where federal marshals are concerned. The question to ponder is, just how much guff and oppression must a citizen take off a misbehaving official who is unidentified? The basic law of any free society is that a person has the right to defend himself and his property from anyone unless legal due process has been afforded him to the contrary. Yorey's pistol, with the .38 slug embedded, finally turned up from a trash can plant during closing arguments at the trial. This caused quite a procedural stir, but mainly it confirmed that Muir started the gunfight. So what, said Crooks. He had a right to. I'm just glad he at least got to hit someone before he was killed. In addition to the life terms for Yorey and Scott, Chief Judge Paul Benson imposed 15 years of consecutive sentences. These were 4 10-year concurrent sentences for assault charges and 5 years for harboring. Another 5-year concurrent sentence for conspiracy to forcibly assault was also imposed. David Brower, acquitted of assault, was given 2 consecutive 5-year terms for harboring and conspiracy to forcibly assault. Lynn Crooks was flown to Washington and was honored for his successful prosecution. Irvin Nodland waxed eloquent in voicing President Reagan's quotation of C.S. Lewis' Screwtape Letters. The greatest evil is not done now in the sordid dens of crime that Dickens-like character paint. It's not even done in the concentration camps and labor camps. In those we see but the final result, but it is conceived and ordered and moved and seconded and minuted in clean carpeted, warm and well-lighted offices by quiet men with white collars and cut fingernails and smooth shaven cheeks, who do not need to raise their voices. And the government didn't seem to start out this case talking about those things, philosophies, etc., implying these defendants' beliefs would constitute some sort of creeping, insidious threat that had to be destroyed or stamped out. And with calm assurance you were told in the opening statement that what this case is not about is his political beliefs, whether taxes, religion, or philosophy. We could not care less what they said, but somewhere on the road they abandoned that stance and they took a pail of slop and they walked over and poured it on top of Scott Fall's head, because things from the evidence of what happened at Medina weren't going the way they thought they would. And 12 hours into the trial, we received evidence of things that happened a year ago that we are not prepared to challenge, like we were with Susan Reardon. They abandoned and they promised in their opening statement. He then stated in effect that since they haven't been able to get Gordon Kahl, they want to get their pound of flesh from someone. This case represents a combination of factors that have come together on the 13th of February to produce madness. There is plenty of fault to spread around, including my client and the other defendants. There is a freak accident, negligence, and there is carelessness. There is machoism and there is insecurity. There is stupidity dripping all over everyone. We start this case with a minor misdemeanor violation, the principal penalty of which was inflicted and served by Gorton Kahl. There was a court form reporting violations and a man too stubborn to throw it out because it violated some principle he had. It was over 5 years gone by from the original conviction, 3 years of an unserved warrant, meetings and negotiations in lieu of arrest. Finally, there is a directive from the National Marshal Service to file it away, not spend any more time on it, and then it was executed. I think there is something behind this chart that I'd like to get out, and that's Government Exhibit 11E, and it represents the response to the National Directive of Marshal Service that it be filed away. That's how it was filed. That's how it was filed away. It was executed in unmarked cars by uniformed officers in flak jackets and AR-15s on a Sunday afternoon, following what we were told was a religious meeting with 11 innocent people and children in the immediate vicinity of the Reardon driveway, and it included among those 11 innocent people my client, who had been driven to virtual paranoia by false police APB about him or his car, by news articles about circumstances in Utah, by a surveyor with binoculars, by a tip from someone who is unidentified that there is a setup or a trap, and then at the moment when the warrant was executed, there was a tornado of verbal obscenities and threats. You're going to die. You're going to have your head blown off. Threats of unmarked, ununiformed people holding firepower and the sufficiency to carry out those threats. And when my client flees from the scene or retreats, as Mr. Crooks called it in his opening statement, he's cut off or contained, as they said, by yet another unidentified and yelling person lying prone some 75 to 100 yards a football field away. Darrell Graff knew that this was insanity. I think Bud Warren knew that it was insanity. Graff said, "They are going up there to shoot a tax evader, and this time the police are wrong." And he called the ambulances and rescue squad and got out a crew. And one of the questions that I have asked myself from the beginning in this case, I can't answer it, as I tried to put myself in Scott's shoes as he was out there. When is a citizen obligated to assume that people who are not acting like police and who do not look like police are nevertheless probably police, so as to require immediate submission to authority and to threats of death? Can you throw a hand grenade into a crowd and then demand strict accountability of those who trample others in the panic to escape? I think the court will tell you something to the effect that if Scott had reasonable grounds to believe, and did believe, he was in danger of death or serious bodily injury from which he could save himself only by use of deadly force, then he had the right to employ that deadly force. We lived for a number of months thinking that Cheshire's death was the principal issue in this case. You know what I think the principal issue in this case for Scott Fall is now? I think the government has given the testimony of Curtis Pellet as its principal thrust, hoping that somehow or other, because of something that may have happened and may not have happened last year, that you will think, Scott Fall is a bad man, and it doesn't matter what happened at Medina. Scott Fall's fate is absolutely in your hands. It's beyond mine and it's beyond his. He is ready to accept your judgment of his conduct on this day in accordance with the rules of law that the court gives you at the end of these arguments. What you have by way of evidence in this case is saturated with mistakes and errors and omissions, but I guess I'm saying to you, I don't really think that matters a lot in this case. On the abstract canvas that has been created for you now by the lawyers and witnesses, I think that you can see the globs of paint that have been heaved in many instances were simply not true. People have come in and said Scott was at a meeting and said this heinous thing, and 10 minutes later said, oh, maybe somebody else said that. And when Scott explained it to you what he was, when he was on the stand, what that was all about, it turned out to be the opposite of what had been indicated. The full force of the federal government has been brought to bear in this case. All of its resources, investigators, its marshals, its FBI, U.S. attorneys, they have put onto pieces of paper what purports to be a preservation of the evidence. Witness after witness then came here, looked at those statements and said, I don't think I said that, or they left something out. yesterday when Scott was on the stand in rebuttal of the statement that he gave to the FBI, he made a statement to them that Gordon Kahl told him that he walked around the front of the Ram Charger firing at the door at someone who was crouched down behind the door and finally moved around to finish him off. That statement didn't even find its way into the official 302 report of the FBI. When the printed word falls and there is nothing to establish preconceived idea that the government has had here, and there are no videotapes or other tapes, we are given a piece of manufactured evidence. That photograph of the Ram Charger with the streamers coming out of it, the only thing that's accurate about that photograph is the rear end picture of the Ram Charger. It is, in fact, the Ram Charger. Nothing else on that photograph is actual, but it probably doesn't matter. Abstract paintings allow for great poetic license, even when it's done with precision, with careful analysis. Like autopsies, you heard in this case that experts can vary between a quart of blood and a teacup in describing the same thing, and when you find out how it's measured by sloshing the hand in a cavity, the defense we are giving you here is one of self-defense that is justified, that was based upon the circumstances. And even though there are parts of the reliance that Scott had that latter proved to be inaccurate, that since the APB that was false, that we are entitled to that defense towards any crime that may be charged, whether it's the mayor, whether it is a major offense, or whether it is one of those lesser included offenses. The government has the right in this case under the rules to go last. That always worries me in a great deal, because the psychologists tell us that which we hear first and that which we hear last makes the greatest impression upon us. It's called the principle of primacy and regency in the psychology books, and I am concerned about that. The other defense attorneys made equally impressive arguments, especially against the other kitchen sink charges. Judge Benson charged the jury not to discuss the jury deliberations or how they had come to the verdicts with anyone after the trial was over. Was this something to hide? He had no right to do that, as a dismissed juror is no longer under court jurisdiction. Robert Ramlow had some interesting comments, assuming lawmen should use common sense. He said, "Where does it say put on badge, park brain? You can do some wrong things that are illegal and some legal things that are wrong." It seems to me that all they wanted to do was arrest Gordon Kahl. I mean, you don't have to know much about law enforcement to know it ain't real smart to arrest some guy that says he ain't going to be arrested and he's got some other guys with him who've got guns. I don't have to read a manual to figure that out, unless you're looking for trouble, unless you want to try to make an example, or unless you think you've got so much authority that nobody dare oppose you, no matter what the circumstances. But for some reason they went out there and did that. The government's attitude is, if you were there, you are going to pay for it. Wonder what a hitchhiker's chances of staying out of jail would have been. Had Brower given someone a lift as they left town? The only thing dumber than throwing a kid out of a school for truancy is to put someone in jail for being a tax protester. Let him out of jail even though he says he won't file returns, and make it a condition of his being out of jail that he file taxes. And then he doesn't file taxes and he's go looking for him to put him back in jail. Somewhere along the line there ought to be some common sense and reason, especially from the government. They should have considered what would happen before they pulled guns on people and started hollering, "You're gonna die, and we are going to blow your heads off." So the government now has 3 political prisoners. The cost to taxpayers is roughly $50,000 per year. And so it is that branches developed and some fruit ripened from this poisonous tree planted on the plains of Texas in 1977. The Supreme Court refused to hear the case. That's not unusual, I'm told, especially for a case related to personal income taxes. Lynn Martin estimated the trial cost $100,000 for taxpayers, with the total Kahl affair being some $3 million. In the next part, we'll pick up at the top of page 165. That will be chapter 24, Quo Vadis. Quo Vadis.